So the course rep is who?
Mr. Chinelu, sir.
Great. Okay, so let me co-host so that
Barrister Chidelo.
Mm.
so good enough once more. So who can recap what we did last week? Someone should recap what we did last week.
Sir, you taught us about contracts, agreements, and the difference, as well as some of the characteristics, and you also taught us about offer, making an offer, offeror and offeree.
Yes, who else? Who else? Who else? Who else can? Yes. Yes, who else can add a voice to it? Who else can add a voice to it? Yes, 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 yes. Who else can add a voice to it? What did we do last week? You should have your notes with you. What exactly did we do last week? Yes, yes, yes. Adeyemo.
Yeah, we also learned about an understanding of communication.
Adeyemo, please. We can't hear
Can you
you.
hear me, sir?
It's
Can you
faint.
hear me?
The voice is faint.
Oh, yes. Can you hear me?
Okay. Is it raining where you are?
Um, easy. Okay, so we learned about, we had an understanding of what an invitation to truth is and difference between invitation to truth and an offer. Then we went further to understand how an offer can also be terminated. We looked into um, withdrawal, rejection, the debt of the contract as well. Then that's basically what happened.
Okay. Okay.
Yes, sir. Good
Uh,
evening, bro.
yes. Yes.
So we looked at the Kalili and the Smoke Ball Company in
Okay.
1893, and we looked at the case and we talked about invitation to treat and offer. Yes, that's we elaborated more on that, which helped us to highlight the topic we're looking at as our last week.
So what happened in the case of Kali and Kabul Soboko? Do you still remember the
So,
gist?
so, so the company denied to give
The
the
lady.
customer the £100 that he promised.
Why?
So because it was an invitation to the public, not to any specific person. That's what I can remember.
Okay. So what did the court say?
The court,
What was judgment of the court?
the court requested that the company pays the customer.
Because there was what? What was the reason that was given by the court?
I can't remember specifically, but I know we
That
looked
means,
at that case.
that means you know what you guys are telling me is I know. Since that day, this is the first time you are opening your visiting your notes on contract. That's the meaning of what you are saying. That you never visited it. You're not visiting it just now. Right. Yeah, that's the meaning. Okay, let's continue from there. So essentially we'll look at what is offer, the those elements of a good offer. We'll look at the rules surrounding it, and also look at how the offer may be distinguished from invitation to treat. We'll look at those instances of the distinction, the flow of goods in the shop, passengers standing at the bus
Sir,
stop,
hello,
tender,
sir.
and all those things. So today we're looking at the second element.
Hello, sir.
We'll look at, yes,
We have done this slide, oh.
you cannot see the slide.
I said we have done this slide.
I know now, but are you hearing what I'm saying? Are you hearing what I'm saying?
I'm hearing you, sir.
Yes, Ogochukwu. So go ahead. What did we discuss? What happened in Kali and Kabul Simple Company?
Now, I was only trying to tell you that this slide you are showing on now, we've treated it last class.
I know, but I'm also asking you a question. Now that you come on board, I also want us to help us. What happened in that case?
Okay, the case was
It's not about slide. It's not about slide now. It's about whether you still remember what we did last week.
yes,
Because
the
it
court
appears to me
ruled
that most of you are just seeing this for the first time after since last week. Go
the
ahead, go
judgment
ahead.
of
It's
the
your time.
court.
Go ahead.
The judgment of the court was that the offer made by the company was a public offer and is a valid one. So therefore, they are bound to pay um, what they say they're going to pay. So they should pay.
Are you a stamina? Cancel. Are you a stamina? Ugochukwu?
Hello, sir.
Are you a stamina? Hmm?
No, sir. No.
See your own now. That means you're not ready the case again. Since that time, you're just seeing it for the first time, right? So so we are looking at the second element of valid contracts, which is acceptance. As I said, if you look at the element of valid offer, we say that the offer is made to the by the offeror to the offeree with the intention that once it is accepted, then it becomes binding on the person making it. That is the offeror. So is that acceptance that we're looking at here? Now, just the way we define an offer as a definite expression of intention, it then means that acceptance also by law must be final, you know, and not just being final, it must be final in terms of in line with the terms of an offer. And so, by way of explanation or description, an acceptance, as you can see on the slide, yeah, someone should read that slide, that first paragraph, so that I will know that we're flowing together. First paragraph, someone should read it.
An acceptance is a final expression by the offeree that he agrees to the terms of the offer as conveyed to him by the offerer.
Thank you so much. So you can see that why we are saying at the beginning, I mean, last week, we emphasized the fact that it's the offeror that makes the offer to the offeree. And of course, we also look at the ways by which an offer can be terminated, which if the offeree feels that he can reject the offer, he can also reject or he can accept. And so we're saying that how can we not describe acceptance, on this one as being the fundamental element of a valid contract? It's a final in the sense that nothing else is to be done. Remember that everything about contract is about manifestation of what the parties have in mind, because there's no way that another person will know what you have in mind unless that intention is manifested. I will say that in terms of contract, what they're looking for is consent, and that consent must be freely and willingly given. Not gotten by force or by making representation or by mistake or the case may be. Right. So acceptance, is also by the way by which the offeree also expresses his own intention towards the offer made by the offeror. So it has to be final finer so that know that once already the offeror is one that gives consent by way of an offer. So if the offeree also gives his consent by way of acceptance, then you say that the two minds have come together, and that's what they call in Latin, consensus ad idem, two minds coming together, and that is the point that the contract comes into existence. So, but for acceptance to be valid, it must do what? Must correspond with the terms of an offer. So that's why we're saying that it must be unqualified, it must correspond to all the terms of an offer. So it must that's another way that describe as being the mirror image rule. All of you that have mirror in your car, mirror in your offices, mirror at home. You know that is the way you dress that you appear. If you stand before a mirror, is the way you dress that you appear in the mirror. So you cannot, you cannot, you dress in a particular way, and then the reflection in the mirror cannot be different. You know that if it's different, it means that something is wrong, and I know that you run away. So that's what I say. It must mirror the terms of the offer. So once you accept and there are changes in that acceptance that are different from what is contained in the terms of the offer, then that cannot be a valid acceptance. So, and that's why they say that look, once it's accepted, it's deemed that there's no any intention to go further on the bargaining again. Remember that the stage of bargaining are the stages that we talk about, the issue of invitation to treat, those preliminary stages that parties, those are the stages that you have to negotiate and all of those ones. So, example of University of Lagos, your admission letters, for instance, although it might not be known that way, or maybe your tenancy where you want to lease a property for your office or your business, or all of those ones. You could see that if, for instance, the apartment, the shop or the warehouse they want to lease was offered to you at terms A, B, C, and then you're accepting it, you also added term D, or you remove C from it. It could just be address, it could just be a name, it could just be the monetary term, whereby the offer is to for you to rent the apartment at a particular price. You agree, but you ask for rebates. Ask for rebates. Yeah, the two lights at my end, and I need to reconnect to another source of data. Okay, the slide is lost. Need to reload it. Can you see the slide now?
Yes, sir.
Okay, thank you. The light went off. We need to alternate to another source of data. So, as I was making the point, so it must mirror the terms of NOFA. And of course, we know that in the course of bargaining, at those final stages, parties we make statements, express their intention. Other ones, they will accept and add some things to it and things like that. So the point one is making here is that look, you know, the the acceptance must be such that to suggest that there's no intention to go on again with bargaining. It means that the two minds have come together. Now, there's what they call, the consequences of that is that where the acceptance did not mirror the terms of an offer, or is not correspond with the terms on offer, then it is termed as invalid type of acceptance. So that take us to another subtopic under acceptance, on which is the subtopic on one of the subtopics under acceptance, which is invalid types of acceptance. And number one that is important for you to note here is what they call a counter offer. Very important for you to know is counter offer, because this is the most common one that appears, on your day-to-day, business activities. Now, a counter offer, as you could see in the slide, is any qualification or amendment of the terms of an offer. Now, as I said, over for a list of a property, for instance, the offer has been made for the list of property. Now, in accepting the lease, you introduce another term requirement. Maybe the property should have AC, there should be ties, there should be this, which are the terms of the offer. So, because you have qualified that acceptance, you are accepted with condition, with something else attached to it. The what that means is that alteration have change the narrative. It's no more showing the two minds are together again. Remember that for a contract to be constituted, the two minds must consent, must be together. Now, but where there's alteration, of the terms of the offer, as I said, it constitutes a counter offer, and that is not a valid type of acceptance. So you will see that in the course of bargaining, for instance, you would have experienced a situation whereby maybe a common thing, you're going to shop for a contract for the sale of provisions in the store, for instance. You pick an item. Of course, we have seen we were treating offer that goods display in the shop. By general rule, they are not offers; they are invitations to treat. So, but when the customer pick a particular item, that customer is the one that is making the offer. So it's not left for shop owner to accept. Now, assuming that you pick the item, even if there's a price on it, or even there's no price on it. Now, on getting to the counter, the price that is the customer is saying is not the one that is on the owner of the shop. You see the price on it, but the owner of the shop is saying, no, we're not selling at this price again. The price is different. You see that the offer you have made, the customer want to say to you, but he has introduced a requirement which is different from what exactly you have offered. And you may also say, no, you will not give this amount. You can only afford to pay this amount. By you saying that you can only afford to pay this amount, you are also counter what the person have said. That person will say, no, okay, add this amount. Then I will reduce it this one for you. He has also counter what he has made. So you can see that there are series of moderations, alterations that go on when parties are, trying to make sure that the two minds they should consent and this contract to that effect. Now, so in one transaction, they will counter offer upon counter offer upon counter offer upon counter offer until it get to a point whereby it is clear that the parties intend not to go further again. That you cannot say that a contract has been constituted. So the effect of a counter offer is that it destroys the original offers. So what I mean is that if Chinelu is the one that made an offer initially to Adeyemo, now you're accepting that Adeyemo now introduce a requirement of rebate or a reduction on the price. Now by adding that rebate to the acceptance, at that moment it becomes a counter offer. Now Chinelu, who was the offeror, and why the Adeyemo was the offeree, once Adeyemo has introduced any qualification to that acceptance, means that that offer made Chinelu has been destroyed, is no more alive again. So it is a statement made by Adeyemo that becomes a new offer. So what I mean is that even if Adeyemo want to change his mind and go back to the previous price that Chinelu offered, it will be too late. So once a counter offer is made, the previous offer has been destroyed, is no longer alive. You cannot even go back to it again, as far as the law is concerned. So it's the new statement made, it's new offer made that becomes the new offer. So you see that if Chinelu was the offeror, making an offer to Adeyemo as offer or as offeree, if Adeyemo now or introduce a new term in that offer, then that acceptance has destroyed Chinelo's offer. Then it's Ademo's purported acceptance that will become a new offer. So if Chinelo was the offeror and Ademo was the offeree, now that the offer of Chinelo has been destroyed by Ademo now become the offeror, while Chinelo will become the offeree. Now, if the Chinelo also counter it again, you will see that they will swap again. Chinelo will become the offeror, Ademo will become the offeree. If Ademo also counter it again, you see that Ademo will become the offeror, Chinelo will become the offeree. Now they will keep. This is just what goes on in the transaction and things like that until you get to a point that you see that there's consent. The two minds come together. So in one transaction, you could see counter, open counter offer, open counter offer, open counter offer, open counter offer, until the point that you see that the two minds have come together. But the point we're making is that look, is what they call the effect of the counter offer is that it destroys the terms on offer. So be careful. Even in project that you are doing, even in contract that you are doing, you are giving a contract offer to come and do a construction or supply goods, and then you're accepting that you introduce a new term to it. Know that amounts to a counter offer. And the effect of that is that offer which was given to you has ceased to exist. So if the person go ahead and transact with someone else, then of course you know that cannot be a breach of contract because of the fact that you added something new to the terms of that offer. So even your admission letters, you have a contract with so Lagos, which you want to secure your MBA certificates. Terms offer admission letters were given to you. Assuming that in the course of accepting your admissions, you don't say, your tuition fees will be splitted into 3 times for you to pay. They are, just giving one of the examples anyway. But there are many of them there whereby people engage in communication over in offer. This one will counter it. This one will counter it. This one will counter it. Series of counter offers can take place in one transaction. So there are cases that are there for you to read. And I said, note that the effect of a counter offer, once the offer is made to you, and in accepting that offer, you introduce something new. In law, that offer made to you has gone. You can't go back to it again. It has been destroyed by that new thing that you introduced in the purported acceptance of the offer. It has gone. So it's you that have become the new offeror now. The person that sent that offer to you will become the offeree, and is also have the right to accept or reject. Of course, you should take note of all those things. So there could also be a situation whereby acceptance will be made subject to contracts. When acceptance is made subject to contracts, the effect is that the validity of the contract is suspended until a formal contract is entered into. And this practice is very common in sale of land or interest in land. In the purchase of property or land or lease of property or land, for instance, there's no way that someone can just walk out to you or you want to go to someone and say, I'm the one that owns this property or I'm the one that owns this land. and then you just carry money and give the person like that. You would have done what the due diligence, background check to find out, to confirm whether this person owns this property or not. Now, in doing that, it may take time. Or there are some things that the person you may ask that person to put in order before they, put in order before they, um, you make payment. Now, there are sometimes that someone will say, "Oh, bring commitment. Let me show make some payment as commitment." You know, so you can't just give that person money like that. Now, you would have given someone a percentage, maybe 10% of the lease amount as commitment, but then you must also put something in writing. Now, while you are paying that 10% as commitment, there's an agreement that you entered into. And that agreement contains a clause, maybe at the beginning, maybe in the middle of the agreement, maybe at the end of it, that has subject to contract. So what we are saying is that you want to, though you want to go into an agreement with this person over this property, that the transaction is not valid until a formal contract is entered into. So you can always state that, oh, the person has received X amount from you based on this transaction, but all of this, what you have on ground here in writing here, is subject to contract, subject to the subsequent agreement that you will now enter into, in that regard, right? So, and you could see the case of UBA with Tejumula and Sons, where UBA wanted to lease a property to. Yes, someone can just. Can someone? I think this case will be online as well. Can someone Google this case and let's see? Let's look at it together. UBA and Tejumula. Yes, 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 yes. Can someone just like a minute or two? What happened in the case? Have you seen it online? Google it.
So,
Am I here?
in the case of, can you hear me,
Is
sir?
that is that Imon Precious?
Yes, sir.
Okay, go ahead.
Okay, in the case of UBA versus Tejumala and Sons, the Supreme Court of Nigeria held that despite the conduct of the parties, that there was no binding contract for a lease agreement, and the court found that the phrase "subject to contracts" in the offer letter indicated that the parties did not intend to be bound until a formal contract was executed. Do you want me to go
Good.
to the key facts?
But what happened in that case? It's a very pathetic situation. Are there any summary of the facts or what happened in the case?
Yes, United UBA offered to lease a property from Tejumala and Sons for 15 years. The offer letter was marked subject to contract. The commencement date
Yeah,
of the lease was not explicitly agreed upon, and both parties took steps to prepare the property for lease. Then UBA later wrote to Tejumala and Sons calling off the negotiations, and Tejumala
exactly,
and Sons then sued for breach of contract.
exactly. So we see that. So that was, and if you read details, they will, you see that they asked them to change all the windows, they change all the furniture, they change all the ceiling, they change, repaint, they repaint, put this one in order, they put everything. At the end of the day, they say they're not listing the property again. So that was, imagine, Precious now wants to lease a property from someone, or someone wants to lease property from you. And the person say, no, you have to change the roof, you change the ceiling, change all the doors, you change the window, you change all the things, you change. I know the person does say, what, Precious, know what, I'm no more listening to your property again. Where you have, if I ever tell you has even gone to borrow money, they're going to borrow money to even do the renovations to the test that you. So see how powerful that's an agreement that has a subject to contracts, in text. So as businessmen and women, you have to watch out when you pick a document go around it and check that you will enjoy under that document. Don't just put your pen down, because that word alone, that phrase alone, subject to contract, has suspended all the benefits that are in that document. You're just like still negotiating, until that formal, contract is entered into. Right. So that is the effect of it. Now, the question here also is whether silence amounts to acceptance. Because the rule is that silence does not amount to acceptance. And one of the famous local classicals here, local classical is the case of Fate Houses Binley. This also, I want someone to read it out for us to see what happened in Fate House case. What happened in first Fate House case? I'll give 1 minute. I expect people to check what happened in that case. Yes, who's speaking? Are we together? Is Chinelo in this class?
Yes, I am, sir. I just wanted other people to talk. The First House versus Bindley case, there was an offer. First House offered to buy his nephew's horse in pounds, 30 pounds, 15 shillings, stating that if he did not hear from his nephew, he would consider the horse his own horse. Then the nephew did not say anything. There was silence. And the Bindley now mistakenly included the horse in an auction where it was sold. There was an auction, and the horse was also in the house, so it was sold mistakenly. So Feldhouse now sued Bindley for selling his horse, arguing that the horse's silence, quote and unquote, constituted to an acceptance of the offer that he had made, and it was also some sort of contract for sale of the horse to him, Bentley. Fell's house. Then the court ruled a decision. It's an 1862 court case between Paul Feldhouse and Mr. Bindley. So the court ruled in favor of Bindley, stating that silence cannot be misconstrued as acceptance in can be misconstrued. Can be misconstrued as acceptance in contract law, and that the nephew's instructions to Bindley were not sufficient. There was no contract, and therefore Feldhouse did not have ownership of the horse at the time of the auction.
Yeah, thank you so much. You see, as we're reading, I expect others are also reading it. The locus classical, and of course, you see that the same thing was applied in a Folabi's case. And you can read that quotation. There's a quote. There's a quotation there also. You can also look at it. Yes, who can read that? She wants to read that quote on the slide.
Please read.
Yes,
Please
go
read,
ahead.
study carefully, and sign the document and sign the duplicate
That's
copy
plaintiff.
at
The plaintiff. I hope you know the difference between the plaintiff and the defendant.
Yes, sir.
Okay, that's fine. Go ahead. Go ahead.
Okay. And sign the duplicate copy attached, signifying your agreement to all points as listed above, and return at your earliest convenience for records.
Go on.
There was no
Go on.
evidence that the plaintiff ever returned the signed duplicates. It was held that there was no acceptance. Should I continue?
Exactly. So you can see that. No, that's fine. You can see that. It's very common. That this is happening even professionally. Someone send a document to you, or you are supposed to accept, sign, and send us a duplicate, but you fail to do it. Now, but then if for silence, and if assuming now maybe it's for supply of goods or services, you didn't sign the duplicate and return it back. but you took steps, or you even made a supply, that will be that will amount to acceptance by conduct. So it means that even though they were silent, you were silent, the step that you took, shows that you accepted. Now, but if you just keep it like that, so you just have to watch out. There's some of those things that say, okay, return this in 2 weeks' time, return in 1 week time. So as businessmen and women, you just need to watch out on things like this because if you sign a document you are supposed to return back to the offer and you kept it, that cannot create a binding contract, general rule, because silence does not constitute acceptance. I could see there. Now, another area that you need to look at also is acceptance by post, the post office. Now, here you see the rule is that where it's very common, and you also have to watch out very well when you are entering into agreement with somebody. Look at the means of there's somewhere that they will write to you about modes of communication. In the modern contracts, they will say they will even add email address, they will have WhatsApp numbers, they will ask for, they will even ask for whether it should be a post. So when they say mode of communication, also add post, but you can also post it through post office, things like that. You have to be very careful because of what they call the rule of acceptance by post. This is because the rule of acceptance by post is state that a contract comes into existence the moment the letter of acceptance is posted, not when it is received by the offeror. So you see that there's a difference between posting a letter and receiving that letter. There are two different things. So if you take your office, like University of Lagos, there's a post office. Who knows where there's a post office in University of Lagos? Where can we locate it? Or there's none inside University of Lagos? Is there any post office in University of Lagos?
I mean, I don't know.
Who knows? Have you ever come to University of Lagos, Chinedu?
Yes, we worship together.
Ah, okay, okay. I don't talk. I don't stop now. So now, but you see that if you go to Eco Bank there, if you go to Eco Bank, go to Eco Bank or bookshop, on top of it, top of that building, there's a post office. I think that the last floor or second to the last, I don't know, but they're on top of Eco Bank, that wing that Eco Bank is. So the question is that people go there on daily basis. If there's one, they have their own one post office van. They come there very early in the morning to pick letters and also return the ones that are meant for that place. So this rule is saying that look, if Chinelu, for instance, have gone to that third floor or the second floor and gave, submit that letter of acceptance to that post officer that is on duty, that moment acceptance has come into existence. So even if they keep that letter as the staff of the post office, they kept that for maybe their van has broken down, and they kept that letter for 3 days or 4 days in that office there. Already the contract has already come into existence. So why should you be waiting? We're waiting to know this person. I sent letter to this person. Yes, offer was made, and I did acceptance 2 weeks ago. I have not heard from them, or maybe the offeror will say, I have not heard from this person. When I've not heard from Chinelu, and it's 3 days now that I made the offer, not knowing that day that you send letter, that very day, she will also I've sent the acceptance and has posted it because the terms of the offer itself said that acceptance can also be by post. I posted it. So even if it takes 1 week, 2 weeks, the person cannot do anything other outside the terms of that offer because the contract had already come into existence. That is the power of acceptance by post. So assuming that you were waiting to hear from Chinero, 4 days you didn't hear. On the fifth day, you just sold that goods or whatever you want subject matter of the contract to someone else, or you go into a contract with someone else over the same subject matter. Know that will amount to breach of contract because by rules of acceptance by post, the contract had already come into existence 4 days ago. So you watch out. And this was also established in the famous case of Adams and Lisa. So Adams and Lisa also let's get someone to read this case for us. Yes, check for it and tell us what happened in this case. Yes. So I give 1 minute or 2 minutes for someone to read. Use your phones or your laptops or your learning mat, and let's hear from you. Who is a Zoom user? Who is a Zoom user? Is he a spy that is just spying our lectures or what? Chinelo, please discuss with the Labiton. It should add you as admin so that I can checkmate these people here. Remove those names. People that we don't want to use their real name. Remove them. We don't want to have real names. We don't want to see iPhone,
Okay,
Samsung.
sir.
Yes, talk to him to add you as admin, and so I can checkmate these people here. I don't know where they're coming from. Maybe they want to spy us, or they want to get lectures free. I don't know. We must pay. Maybe no knowledge is free. We must pay and there. So yes, who has gotten the case now? Afiz, Ayatunji, Ayotunji. Oh yes, Afiz, have you gotten the case? One to Nena. Have you seen the case? Chibos or Daniel? Have you seen the case?
Can I go?
Okay, go ahead.
All right. So it's an 1818 case between Adams versus Lindell. It was for the sale of wool. I think it's the sale of wool, yeah, where the offer was delayed due to a misaddressed letter. So, and the as of the time when the offeree did not receive the acceptance was posted but arrived late, and the offeror had already sold the wool to someone else because he didn't hear from the offeree. And the decision of the court was that um, the the contract upon being posted, regardless of when the offeree receives the acceptance, is binding, such that except there are cases where it states in the website that it excludes that rule. So at the end of the day, the the court held that the contract was formed when the acceptance was posted, even though the offeree received the acceptance and received the contract late from the offeror, which is Adams.
Okay, let's hear from someone else. Yeah, I think Precious, your hand was up. Imo.
Better. But I think I'll say the same thing Chinelo just said. It's in case um between Adams and Linsell, where Linsell offered to sell wood to Adam by post, and she misdirected the initial offer that caused a delay in its delivery to Adams. And upon receiving the offer, due to the delay from the postal people, Lindsay received it, and after the date, he expected a response because it was way past the due dates. And then before receiving Adam's response, Lindsay had already sold the wool to a third party. But the court's decision at this point was that a contract was
Yeah,
formed.
look for the one that have the dates. The dates, the average periods that were written on. Letter was wrote on the 2nd of September. Those. That's how it can help you. The one you are reading there is not really provides that clear something, because the issue was that they were expecting. Letter was sent, and the plaintiff in this case, um, you know who is Adams, got the letter on the 5th, and on that very 5th, he also posted the acceptance, and because there was a delay, you know, the letter would have gone back to the overall on the 7th. But because of delay, they didn't see it on the 7th. And on the 8th, you know, listen. Sold the wood to another person. Then on the 9th, he now received it. So the question was that whether at the time I was selling that wood on the 8th,
Sorry, sir, your voice is breaking.
whether the 5th
We can't hear you, sir.
I think your network is bad. Your voice is breaking off.
was already Can you hear me?
Can hear
Hello?
you now.
It's better now. Okay.
So we can't hear you again, no.
Hello. Network is bad. Hello, can you hear me? Hello.
Yes, sir. Yes, sir.
Yes, sir.
Okay.
Yes, sir.
Okay. Can you see my slide?
Yes, we
Yes, sir.
can, sir.
Okay. Yeah. So as I said, look at the rules. Look at the rule in Adam's release. You know. So this should also be very cautious as businessmen and women. You know, when you pick a document, method of communication, very important, so that you don't engage yourself in a situation whereby someone will send a communication to a post office, their van is down, the staff are protected. When in fact the transaction has already commenced as at the time that the acceptance was posted. So you have a discretion in why negotiating to exclude, to remove that completely if it's contained in the terms of offer that look, oh, you won't want to accept anything through post office. You know, you can use other means. Even the context of email correspond the same thing. The question that debate is that if we send a correspondence to someone by email, is this the postal rule apply? Is it that mail you send it? You know, is it the moment that acceptance will come into existence? You know, when you used to email, or until when that person received that email the other side, and then how will you know that email someone received email the other side? You know, because once you send an email, you don't have control over it again. So in some countries, they enacted specific laws, you know, telling us that, oh, he said that when until a party receives that email that it comes into existence, or merely you send it, it comes to existence. In Nigeria, we don't have that kind of law yet. Because even the e-contract bill that is National Assembly, it has not been passed into law, you know, since 2007 that the bill was, you know, they initiated it at the National Assembly. So it's still subject to the express intention of the parties. But just note that the issue of acceptance by post, right? So the third, is there any question? No. So the third element of a valid contract is what they call consideration. Consideration is different from, you know, saying, you know, when someone has you know, informed you of something and you say, oh, I will consider. No, that's not what we're talking about here at all. It's not that we consider. That's the consideration we're talking about here. We're talking about the price that one has to pay. You know, we said these are elements of contract because if one of them is missing, then it could be an agreement, but that cannot be a valid contract that is enforceable. So we are saying that every contract starts with an offer and followed by acceptance for every contract. There must be offer and acceptance. But that cannot be sufficient for that contract to be enforced. You must establish that you have furnished something in return. You have paid a price to it. You know. Otherwise, you know, people will just receive appointment letter, offer for appointment as general manager, NNPC. Then you accept that offer as general manager, GM, what you can call it, you know, auxiliary bank or UB as the case may be. You accept the offer and then you stay at home. So every 30 days, you go and just go and ask for the salary, they will pay you if it is like that. But no, the law is beyond that. That look, even though there's offer acceptance, the contract has commenced, you cannot enforce that contract unless you show that you have exchanged something, you have paid a price for it. And you know, that price is also what they call something of value in the eyes of law. You know, so it's the law that determines whether what you have done in return is something valuable in the eyes of law or not. So, by way of description, as put in the slide, is a price which one party pays for promise or acts of another. So you know that even in University of Lagos, for instance, when they give you that admission letter and you accept it, you cannot go and wait, because at that beginning, that is where the contract between you and University of Lagos came in. But you can't just go and sit at home and wait for 1 year or full time or 2 years and then come and demand for your MBA certificate. It's not possible. You must pay a price. That's why both parties must pay a price. What we're doing here. Normal work will end by 4 o'clock, five, or except for those that are posting, but government work usually end by 4 o'clock. It's already past 4, and I'm here teaching till 8 o'clock. Others have gone home. They are taking that they already joined with their family at home. But I'm here in school teaching because of what? Because there's an agreement between you and University of Lagos. So we have to pay a price for university to earn that which you pay. You know. So you also, because you also have to pay a price to get that certificate. That's why you are here. Some of people are coming. Some people are in the market. That's why when you on there are more than 100 people online. But if I call their name, they will not answer me, because where they are is a noisy place. They're either in the market, or they're in the bus, or they're in the car, or they're in the friend, or they're in the office. This thing, they just on this, put it on to satisfy all righteousness, but they can't talk because of the noise where they are. We know all these things. That's the price you are paying. And then exam will come. If you hear that we are going to give you test now, everybody will pay attention. You drop all you are doing, you start reading overnight so that you can pass your test. The same thing in the exams, and things like that. You already pay the school fees. When as this time that things are very hard, you still went to use money and pay. Those are prices you are paying for the contract that you enter into with the University of Lagos. So for every agreement, you must show that you are paying a price for it. And how do they describe that consideration? You could see it there. You could see it there. So once you read the first paragraph, consideration consists of some rights. So once you read that sentence that starts with consideration consists of. Yes, yes.
Consideration consists of some rights, interest, profits or benefits accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered or undertaken by the other. See Curie versus Mesa.
Exactly. So it was the case that, that's the judge described constitution in that way. So you see that in every constitution, you see all this benefit moving. Now, to University of Lagos, for instance, something moved from students, Chinelu, Precious, and Afiz. What are names? I have so many names here. Osho, 129, Chibozo, Adejola, Adebayo, Ayodele. So all of them, something moved from them. Joy is also here. So Oyemade, Olua, Tosin, all of them are here. They would have paid something. So something moved from them to universities as a benefit because they got those benefits. But also, there's also a detriment. So when you go into to go and buy things, provisions in the supermarket or superstore or even the in the University of Lagos here, you are going with 100,000 or going to 1 million, or as the case may be. You discover that if you buy something for 500,000, the shop owner would have benefited that 500,000. But you also lose item. The value of that shop would have been dropped by the value of items that you pick out. You also, even though you have the market, your pocket has been dropped by 100, 500,000, you also gain something in return. So you see that this always exchange of benefits, detriment, undertaking and all of those ones. Even the contract of employment, for instance, the same thing. You must work, you must sweat before you end that salary at the end of the day. Projects, even if you are a consultant, even if you are given a contract to supply, you must work hard to get those goods and supply before you earn the contract for it. So you must pay a price. You must pay a price. So that is what is known as something of value. So you will see that there are rules of consideration. Consideration must move from the promisee, just as we have the offeror and the offeree. And we also have the promisee and the promisor, the same thing. So if University of Lagos promise you that we're going to do XYZ. We give you certificate, MBA certificate, on the condition that you pay school fees, you attend lectures, you write exam and pass. Now, you see that if University of Lagos, the money that you are paid, if the University of Lagos cannot do all that they promise, they will have to refund you money because they did not furnish any contribution to it. But if they've done their own part, for instance, it means that they cannot refund it. So if there's any dispute, University of Lagos is the one that so I promise that I'll do this and I've done. So I'm the one that you have furnished, so it must move to the promise. I promise that I will do this to you under the contract, and I've done. That means you are paying your price, you have furnished your consideration. So that's what they say, that it must move from the promise. It must be something of real value in the eyes of law. So it's the law that determines it. And of course, there are some questions that were asked, whether love, when you do something, somebody because of love, whether love and affection is a price that you pay. In some countries that different
So I think your voice has started breaking up
cases,
again.
in Nigeria, for example, cases whether love is sufficient. Yes, in Nigeria, go and find out. So it's not something of value in the eyes of the parties. The parties may feel that there's something what has no value, then of course that cannot they must be what sufficient. So what I mean is very simple, which is that look, value of the subject matter of contract. So if Chinelu have a building worth 100 million, I can hear you clearly. I can hear you very clearly. So I don't know why my own is. Can you hear me? Am I heard?
Yes, we can hear you, sir.
Yes, sir, but your voice was breaking up before.
It's network. The network is fluctuating here. It's not steady. So maybe you have to remind me when you are not hearing me. Don't let me know quickly so at what point you stop hearing me.
Where you mentioned illustration with love.
You said the value of the subject matter of the contract.
Please, so mute. If you are not speaking, mute yourselves, please. The class governor, please control those that are not muted and are making noise. Femi, you're making noise. Ha. So can you hear me now?
Yes, please.
Okay, so the point I was making is that look, the law is not considered the consideration that is the price we are paying need not be adequate, but it must be sufficient. So the subject matter, if assuming that Chinlu, that's the point I was making, that has the property worth 150 million, but decide to sell that property to someone at the cost of 10,000 naira or 10 million, and it's sufficient for him or her, for her. That's not the business. That's not the concern of the law. So even if the price of the subject matter is worth 1 billion, you try to sell it, to receive only mega amounts for it, and it's sufficient. No coercion, no influence, no undue influence, no misrepresentation, no mistake. That's what you willingly want. Then that is sufficient as in the eyes of law. But even though it's not adequate because that did not the amount of money paid as consideration does not reflect the real value of the subject matter. So it need not be adequate. Because in this case, the adequate money would have been 150 million or 1 billion as the case may be. But she decided to accept lesser amount and it's sufficient to her. Right. You know, for instance, but you know that where you already have a duty to do something and you do it, that cannot be sufficient consideration. So, assuming in the University of Lagos, for instance, there are security men that are meant to provide security. They are paid to do that. Or our Nigerian police, they are paid to do that. Now, if a policeman is patrolling your street, in the course of their duty, and in doing that, maybe they want to save something or to protect you, as the case may be, and then of course they come back, they're asking for that you should pay them. That cannot be. Or where there's riot, for instance, and then police are coming to secure you so that this thing will not happen. And then after that, they wrote to you that you should pay them for what they have done. It cannot work. Why? Because already they have a duty to do that. Or if a policeman already has a duty to secure a place, and you enter into a contract that you pay him money to some that duty. But it's a different thing entirely if you secure any other person except you in that case. So all these people that have a personal aids, personal security, they have to pay extra because the duty of that person is to the whole federation, not to just stand and protect only one person. So it need not be adequate, but it has to be what sufficient. You can read those cases there. And of course, there's also the issue of consideration must not be passed. In other words, when you've done an action in the past, which was not because of a promise made, then you cannot subsequently say that that past action is a consideration for the subsequent contract that was entered into. Akenzwa 2 about Obedi, it's a case that you also need to read. Because of time, I will ask you to go and read the case, but because it was a case involving, I hope you're hearing me anyway. It was a case involving,
Yes, sir.
okay, it's a case involving Oba Obili, who the council, the Benin Divisional Council had a council meeting, and they persuaded the Oba to go and collect their forest from the foreigners. So the Oba, in view of that meeting, went and used his powers to collect the forest from the foreigners. He came back and reported to the divisional council, and the council were very happy, and they promised to give him part of the forest. Then years after, when he wanted to take over part of the forest, they said no, he can't take it, and he now sued that was a breach of contract. And the question was, what price have you paid for the half forest that was promised to you? And he said, no, the price he paid was that he was the one that went and worked hard to get the forest back from the foreigners. And the question was, when you are at the time that you are getting those forests back from foreigners, did they promise that if you do that, you will get half of it? The answer was no. So he did that in the past. That was gone. And it was subsequently when the council was appreciating him that said, okay, for what you have done in the past, let's compensate you. But that statement that was made subsequently, he didn't pay a price to it, but he wanted to use his past action to be a price that is paying the subsequent promise that was made. And the law that was against the law of consideration. Consideration must not be passed. What you are doing, or action you are taking, or the price you are paying, must be in response to an exchange, must be in correspondence with the exchange or the promise made to you to a contract. You can't go back and take or bring what you suffered or the price you paid in the past to be a consideration of what you have in the subsequent contract, as the case may be. So you watch out now. Of course, also consideration must not be illegal or immoral or contrary to public policy. All the things that we frown at, things that society frown at, things that are unlawful, you cannot say that a price has been paid. There are examples of all those armed robbers who went to rob a bank, and they had agreement that look, if we rob the bank successful and we'll get this, we'll come and share it. So they went there, they robbed the bank successfully. So in the course of sharing the proceeds of the crime, one of them was shortchanged. So he went and got a lawyer. He went to court, sued the other criminals for breach of contract. That they before this in the before the contract, they had agreement that look before this they had agreement that look they will go and rob a bank, and that if they rob the bank successfully, they will now share the proceeds in the percentage of how they agree on those percent 20%, 20%. But when they successfully robbed the bank and gathered the juries and the money, they didn't give him his own percentage. That was what this person went to court. So the price is paid there was what he's saying that look, the price, the constitution that he's funding was to participate successfully and to make sure that that crime was successful. That was what he has furnished there, and that was why he was suing that he should be given the part of his money as agreed. So I don't know if I judge on this kind of matter, what do you do? Hello, hello.
Good evening,
I
sir.
hear you, sir.
So if I judge, what do you do? What will you do if I judge this kind of matter? What do you do?
Good evening, sir.
Yes, good evening.
Yes, sir, I wanted to probably ask a question on that because the case of armed robbers, the clause I have here is that can you sue illegality in a legal matter? That case is
I'm asking you now.
that case, does it have a
Yes.
merit to be discussed in a formal setting? Because armed robbery is a legal issue,
Yes.
and in the case of illegalities, those things are just like happen within and it cannot be voiced out because I've seen similar cases when it comes to oil theft, oil bunkering, and the rest of them. When you have cases of oil bunkers, maybe they have groups and gangs, and the one gang override the other. It could be very difficult to involve the police, army, and the rest of them and go to a legal court simply because the business itself is illegal. The Constitution did not recognize it. Therefore, what ground do they have to approach a kind of a court that has the competent jurisdiction to like table such a matter at the initial kind of position, whatever? So the issue is
if I
that
judge,
that
what do
case,
you do?
sir?
If I judge, what do you do? If I judge, what do you do?
If I'm a judge, I would throw over the case. I would throw off the case and ask police to arrest them.
That's interesting. Yeah. you know, so yes, so that we don't waste time. That was exactly what the judge did, though. If you read the case, that was what the judge did. But the judge did not arrest only that, he arrested only the criminal. He also arrested the lawyer as well. The lawyer was also arrested. The lawyer that went to file that matter in court and to defend that criminal was also arrested. Eh? So that was only what they did. So that tells you that is why constitution must not be illegal because you are building something that is what the law is against. Then you want to use that one as a price that you pay to get benefits. It cannot be. That means that law is now you are not promoting using law to promote illegality. As the case may be. There's what they call promissory estoppel. You see on the issue of rule or sufficiency of consideration. So in as businessmen and women, there are occasions whereby someone will borrow you money or someone will from someone, and then there will be a template on repayment plan. But then you may need money so fast, such that if you want to wait for that repayment plan, it may be difficult for you to get this fund because you needed some money. So now you enter into a new agreement and look, you know what? Please give me this money. Just give me whatever you have, and I will forget about the balance. I won't return the balance. I won't bother to disturb you about the balance again. There could be things this way. There could be things this way, in that regard. So the question is that, there's what they call promissory estoppel. The general rule is that look, where you are owing someone, sum of money, a debt, and you pay a lesser sum, that payment of a lesser sum will not discharge your obligation to pay the full balance of it that is outstanding. You know, in that case, we're saying that less amount that you paid is not sufficient consideration for them to forgo the balance that you're supposed to pay, right? But then there are exceptions to it, and these are exceptions. One of them is, you can see it when you introduction of new term, promissory estoppel, composition, and where this accord and satisfaction. Now, the one that will point out is promissory estoppel. That is, a promise, as I said, you have made a promise. Now, yes, this person have is owe you the whole balance and is to pay you as agreed. Now, but if you don't promise that the lesser amount should be you will receive the lesser amount, and that lesser amount will serve as the whole and final, and you not ask for. And this other party rely on this promise. Maybe he has even gone out to look for extra money elsewhere under difficult situation, rely on your promise, gone to get the money, giving you the money. Now, after that, you still want to go back again. The law is that you'll be stopped. The meaning of stop is when they stop you from going back from your promise. You promise someone, the person rely on it. That if you were to withdraw your promise, it will cause harm, injury to that person. In that case, the law will stop you, and that's what is known as promissory estoppel. So I'm just as businessmen, you have to be very careful when you are giving people all sort of promises left and right, particularly if you give those such promises and the person rely on it and you start withdrawing. So as businessmen and women, when you are speaking from two sides of your mouth at the same time, you have to be careful because the law they will just play the defense of promissory estoppel, and you will hook in one place and things like that. The same thing with accord and satisfaction. Those are things I needed to also point out for you to also take note of. Right? So there's the fourth element of contract, which also look at, which is the intention to create a legal relationship. Now, we had already said that there's no. I hope you are hearing me. Please let me know when my voice is cracking or you're not hearing me again. Very important. So, the issue of intention, there's no person that's superhuman that can know what goes on in that person's mind except God. It's only God that knows what goes on in his mind, right? I usually tell students, there are some students that don't want to, once they come to University of Lagos, don't want to graduate. So even if you are teaching, because they made up the mind that they want to stay here for 4 years, no matter how you are teaching, they will tell you, within them, they made up their mind that they're not going to graduate. And of course, you know, and of course, know. And then of course, if for instance now, people are superhuman, even the exam question that lecturers will set, you already know what the lecturers have in mind. You would have known before the questions are set. Is it not so? But you won't know. So the lecturer will come to class be teaching you. He has a particular area that wants to set the question. You will not know. So that's exactly what happens when you are going into a contract with somebody. That's why there are some contract you go into. When you hear that someone dupe you. Oh, it's a 419. Oh, it's a fraudster. This and that. It means that when you were going, the other person had in mind to commit fraud to you, to dupe you. You didn't know. Because if you knew, you would have run away. You wouldn't have entered that kind of agreement. Is it not so? Those are God's will. Is it also when you know that someone is there to defraud, will you still go into that contract? If you can read the intention of that person's, those are, will you do
Yes,
that?
sir.
Exactly. Will you still go into that such contract? The answer will be no. Is it not so?
Yes, sir.
Hello? Yeah, exactly. So now because you cannot know what goes on in another person's mind as businessman. So I'm just bringing your attention to the fact that as businessmen and women, don't just trust any relationship, any contractual relationship that you're going into, because you don't know what's going on in that person's mind. So you have to be very careful, always be diligent in your negotiations, because you don't know what is going. There are many people that collecting money, even the collecting money and the jackpot, they disappear. You can't see them again. So but if you knew that this is what this person wants to do to you, you know, contract or marriage, some people have gone into contract or marriage because they want to travel abroad. So assuming that, and that's all. Once they travel abroad, that marriage has ended. Though it has ended. So assuming that you knew that this person will marry you and say, okay, don't worry, let me go first. I'll come back and carry you. You don't see that person, that man again. If you knew that this is what it's going to do to you, you wouldn't have done that. Right. So what do you do now? So in law, we presume intention. We presume intention, and to presume this intention, you have uh, uh, contract divided into three categories: the social and domestic agreement, commercial agreements, and intermediate situations. That is situation that falls in between commercial and social agreement, as the case may be. Now, for social agreements, the presumption is that parties do not intend to create a binding legal relationship for all commercial agreements. I mean, for all social and domestic agreements, the law presumes that parties do not intend to bound themselves by agreement. And one common example is agreement made between husband and wife. Once people are married together, husband and wife, and they are making promises, honey, I'll buy you a car, honey, I'll take you to holiday, honey, I'll do this to you, honey, I'll do this. In the eyes of law, they are just plain love, nothing. It will bind it. I'm sorry, I'm begging you, don't do law at home. I'm not, don't scatter things, don't begin to doubt Oga. Oga, not begin to doubt your wife. Please. I know that some of you will be taking lectures at home, but don't be angry. When a guy is promising, you're making all those promises. Remember that the law is looking at you guys and you are just doing love. And so, if the husband did not buy that car, not take it to the holiday, and it's only quarreling, quarreling about the administration of President Tinubu, making things difficult. You knew, but you are promising your wife. Now you are saying it's Tinubu that is causing all these difficulties. You didn't know before. But you see, it's a breach of promise, but the wife cannot sue you. The husband cannot sue because they're living together as husband and wife. The same thing, you parents, you have tell your children, go to school, I'll send you this one. And if you do well, I'll do this one to you. If you behave well, I'll do this for you. Mommy has always been saying that to daughter or son. Now the son has avoided all friends. The son has gone through a lot of stress so that he satisfy mommy. At the end of the day, mom is giving stories again. Can your son now sue you for breach of promise? No. Because in the eyes of law, those promises are not meant to be binding. Right? But a different thing, if they don't separate, they are no more together again. They are separated. Separated. There was one but case that the mother that wanted the daughter to go and to read law. This lady was working. He had the job, was working, doing very well in another country. Because the mother said, you know what, come and read law. They want say, if I want to read law, where can I stay? So in the school that the lady got admission, the mother got a property there, and where this girl was staying, for to study law. She resigned from her job to study law and things like that. He came. I was then together, all of those stuff, staying together. Been staying and working. Now she could not pass exam. And then the mother now sold the property. Ah, so the question was whether the mother, cannot do that, between the daughters and what that was between the daughter and the mother. So many of those domestic social agreement goes on. Party people are inviting you for party, and you say you attend the wedding, you say you attend the party, you not attend, and they cook rice for you, they keep chicken for you, they do this for you, you didn't go, and the food is wasted. Can they sue you? Even among you classmates, someone say, "Oh, you know what? If I will not able to attend today's lectures, take the notes, jot the notes for me, so that I will, some of them will even give you money. That's the agreement. Take down the notes. Now you did not take the notes. Can your classmates sue you for not taking the notes for them? They cannot. God, these are social agreements. The law presumes that they not intend to bind it. Now, but then for commercial agreements, that's for business. Business is when you come together to you agree to do something in common for purpose of making profit, and the profit is monetary. When it comes to commercial dealing, the profit is monetary, not going to heaven. You're not going to do business for going to heaven. No, it's for money. So it's not morality. So the bottom line there is that for all these commercial agreements where it has to do with money, the benefit is money. The law presumes that the intention is to create a binding legal relationship, right? So between you and University of Lagos, the law presumes that the intention is to create a binding legal relationship because the university is taking money from you and they promise they will do X, Y, Z. It's presumed that they will do something, I mean, the intention is to bind it. Now, of course, those are working, you have MBA, business people, men and women, the business setting or the business environment is a commercial environment. So when you are transacting in the commercial environment or business setting, as you are, the law always presumes that the intention is to create a binding legal relationship. So in that setting, even if, for instance, a husband or a wife has a shop and the husband had gone to that shop to pick items from that shop, there's no issue of love in that one, though, because that one is a commercial setting. So you must pay as a husband. So all you husband that are taking things from your wife's shop are not paying, and that now you are not paying, we are warning you. God the Lord is looking at you. The same thing with the children, right? So law presumes that there should be intention to that because those that are intermediate, it depends. It's a question of facts and circumstances, in each case. So, as I say, the presumption can be rebutted. They're all presumption. They are rebuttable presumption. So even between husband and wife, if you can bring evidence to show that look, oh no, even though we are husband and wife, this promise we intend that it should be binding. If you have evidence, the law will set aside the general rule. So even in commercial agreements, for instance, if the husband pick goods from the wife's shop and they agree, but if indeed they bring evidence to show that look, oh, the intention was not to create a binding legal relationship, fine. That means that agreement, that contract was not enforceable. Fine, you can bring evidence, and the law will set aside the other ones. And of course, there are also some agreement that there's a clause excluding the intention to enter into legal relationship. So even in commercial agreements, there are instances whereby a clause will be in that agreement that will exclude the intention of going into a legal relationship. And one common one is the pool agreement or bet Niger. That's a common one today. People are betting every day, bet Niger, bet Niger. There's always a clause in the bet Niger betting agreement that say, look, oh, this agreement between you and that betting company is in honor only. It's a gentleman understanding only. What I mean is that, look, if you win 1 billion, 1 million, and they fail to pay you that amount, you can't sue them successfully. They'll go and invoke that clause for you. Now, you know what? You already signed here that it's in honor. It's not intended to be binding. So, but you see that not everybody will know this. You see, every morning you see people gather in one kiosk, and I see they're looking for money in one bet. They're betting to do for money. Even if you win that something, the company will say, you know what, we're not paying you, and you can't sue them because you already signed terms of condition. One of them says in that clause that look, oh, you cannot, even though it's a commercial setting, where the law presumes that the intention is to create binding relationship, but that agreement has already taken that out by that clause. So you see that. So you can see this Amadi and all these cases. They use that honor clauses in such agreement. It was very clear. And then also collective agreement, which is from collective bargaining, between parties to a contract in employment relationship where the union, collectively agree with the employers. A collective agreement itself is not binding. It's not binding on the. A collective agreement is not binding on the employer until that terms of the collective agreement are integrated into the terms and conditions, working, what they call condition of service of that employment. That's how those things are, right? So even though it's a commercial, in the contract of employment, not as I say, a collective agreement per se is not binding until it's integrated into the condition of service, or So we see that's why we see that even government, when government minimum wage, when they enact minimum wage, they still have to release a circular into authorizing people to, or all the agencies to comply with it. Or sometimes they'll go and enact a law to that effect and authorize agents to comply with that new minimum wage. Otherwise, it's not binding on the parties. Are we together? Hello, are we together?
Yes,
Yes,
Hello.
sir.
sir.
Okay.
Yes, sir.
Okay. So one last element of contract is valid capacity. I told you at the beginning that there are five elements of valid contract. The last one, which is not displayed here, is the issue of capacity. So generally, in discussing capacity, there are what they call the general rules and the exceptions. General rule and the exception. So the first as general rule is that every person have a capacity to enter into a valid contract. And of course, when I say person, that a person in law means human beings and artificial beings. What I mean is like human being like you and I, and then artificial being like company like University of Lagos, which was created by University of Lagos Act, UBA, Zenith Bank, Dangote Group Limited, all these, agencies that are created by law or restart companies. They are all persons. So we're saying that as general, every person have a capacity to enter into a contract, but then there are exceptions. There are exceptions whereby the law seek to, protect some persons, either in terms of age or in terms of what the parties intend to. So let's look at a company, for instance. You know, Even though we're saying that every company have capacity to enter into a contract, there are some contract that a company cannot enter into. Why? Because of what they call the object clause or the purpose of creating that company. So for every company that's created, there's always a purpose for it, right? So you see UBA, for instance, or Zenith Bank, for instance. You can't see Zenith Bank constructing a bridge, or you can say that they're giving the federal government has given Zenith Bank the contract to construct a new airport, because in the object clause when the company was so it's not for construction of airports, right? You can't say that the federal government are giving Zenith Bank the contract to build new vessel. No, because there's what they call beyond the powers, because that's beyond the powers of the company. University of Lagos, for instance, if you go by University of Lagos Act, there's a purpose for which the University of Lagos was created. It's clearly stated in the act itself, and that's why you cannot see University of Lagos constructing a building, around the lagoon, because that is not their work. If the University of Lagos want to construct any building, they go and hire a contractor, even though they have building engineers in the university as the teachers. You still have to go and hire a contractor to come and do it, because the act did not empower University of Lagos to construct, buildings. So what I mean is that even you, as the staff or the owners of company, you have to check regularly the object clause. It's usually for registered company. You find that in the memorandum of the company. That memorandum, there's a clause that states the objects of the company. Then they'll list all of those things that companies is registered to do. It's very important so that you don't go into agreements that are outside the powers of that company. Because in law, once you go outside, the powers of the company, they call it ultra virus, beyond the powers. And once ultra virus is not binding, you know, it's not binding at all. And I give you an example of someone that a pharmacist. I mean, a pharmacy that a company that wanted to expand their businesses, and so they train one of their staff abroad to become a doctor. So the way that one trained became a doctor and came back, they now want to employ him as a doctor in that chemist, so that when patients come, that doctor will examine them, and they will also sell drugs at the same time in the same chemist. So when the guy came back, he just resigned. He's not working with them again, and they sue him for breach of contract. And so the guy now, the question was whether in the memorandum or the object clause of the that pharmaceutical company, where they have powers to train doctors and to employ doctors for what they wanted to do. The powers were not there. And that was how the guy won the case. and left them and went and started his life as a medical doctor, and then the training that he got from those guys, nothing happened, So even if you are going into agreement with your staff or outsiders, watch out as a company whether that is within the powers which the company was formed because of issue of capacity. You also have infants, children. Infant is someone that is, children is a child is someone that is less than 18 years under the Child Right Act of 2003. Now, the under the Child Right Act, there are two forms of contract. There's contract for necessary and contract for non-necessary. For a contract for necessary is something that is of value in the life of a child, like lessons, like skill acquisition, like tutorials, those things that will add value to a child. So if those ones, like if you hire someone to teach your children extra lesson, right? Or, ideally it's a contract. If you don't pay, that contract is binding on the child. He will pay because the extra lesson is adding value to that child. But assuming, for example, just a contract for supply of clothes, when your children already have clothes, you give clothes to a child, are they needed? That child need those clothes, and then even books, even the food that we eat. Even with that, even children also they differ whether you are a child from poor family or a child from you know a rich family. In fact, some cases there was one case that was decided that a child if you supply a child a bread with butter and it's a poor person, you are wasting your time because to a child of a poor person, you don't need butter and bread and egg. For what? Who will pay for those things? Whereas to the rich child, the background of that child, you're able to pay. So things that are necessary in the life of the child, they are binding on the child. But things that are not necessary in the life of that child, they are not binding on the child at all. So apprenticeship, all of those ones are binding on the child. If there's a contract is entered into that, into add value to the life of that child and things like that. Illiterate. Illiterate is someone that cannot read and write in the language of the contract. So if you are a contract is written in Yoruba language and you are an Igbo person or you are you're a Hausa person, you cannot read and write in Yoruba language and the contract is written. So it means that for that purpose you are an illiterate. If you are a French person and a contract written in English language and you cannot read and write in English, you are an illiterate. If you are an English person and a contract written in German language and you cannot read and write in German language, you are illiterate. So illiteracy is in context, language of the contract, right? So there's a law that's enacted to protect illiterates, and they call it illiteracy protection law. Lagos State, for instance, have one, other states. So that law now stipulates the condition that you must comply with for every agreement to be binding on illiterates. So we see that we started by saying the general rule is that every person have a capacity, but for illiterates, you must comply with illiterate protection law of Lagos State, for instance, before that it will be binding on the illiterate. And one of the conditions is that it must contain a cover to the effect that it was signed before a legal attorney, a law person, and that the document would have read, to, it was read to the illiterate, and illiterate would have demonstrated that look, he understood the content of it before signing. So all of this would have endorsed on the document that this you carry out all of those things, in the presence of an attorney before it will now be binding. So if you sign a contract with the illiterate and you don't have this compliance or this cover page that casts all of those ones that you have done this in the presence of a judge or all of those things, it's not be binding on the illiterate. That is the truth. And of course, even living, for example, for children, for instance, that if you go to somebody that usually buy goods from people's retail shops or warehouses, if you go there, some parents, their children are less than 18 years, when they close from school, they go and helping them to sell things in the shop. If you go and see a child, less than 18 years, selling something to you in the shop, you have to be very careful. Very careful. Don't be smart. The law is not protecting you at all because that child is less than 18 years. Very important. I've seen people, you go to shops, someone of underage selling to you, Where's your mommy? You take it as say, mommy, mommy, okay, oh, be careful. Because such thing, the mommy can come back and ask you know what the item you took, that is not the price that my son gave you. Come and give the money. You'll be angry, but that's what the Lord says. Be careful about all those things. Now, the other one is the other type of person is a mad person. So who is a mad person? Yes, class. Who is a mad person? And whether a mad person can enter into a contract? Who is a mad person, class? Hello, Samuel Benga. Who is a mad person? Can you hear me? Chibozo, yes.
All right, sir. Good evening, Prof. Sir. So a mad person is someone
Yes.
who is not in his right state of thinking or right state of mind, as the case may be.
Do you have mad people in Lagos? Why they laugh? Because someone told me there was one class I asked the question. Someone said, in Lagos, everybody's mad though. Because early in the morning like this, the people are going to work. They're already fighting. You are mad. You are also mad. You are also mad. You are mad everywhere. So, I don't know. So, but then the point I want to note is that in the issue of madness, there's what they call the Lunacy Law. In Lagos State, there's Lunacy Law of Lagos State. And it's that Lunacy Law that determines whether someone is mad or not. So it's not by saying that you are mad, that you are mad. It's what the law says, you know. So the law stipulates that, look, for determining whether someone is mad, you must do X, Y, Z. So once a judge confirmed that, then the person is pronounced to be a mad person. And at that, we're saying that if the person has entered into a contract in that state of madness, it's not a binding contract at all. That person. But at the same time, we see that is possible for a mad person to also enter into a contract, and these are where what they call lucid intervals. Some madness are seasonal; they come and go. They come and go. When it's dry season, the madness will come. When it's rainy season, it will go. Or the vice versa. Or when the traffic is too much, the madness will start. If the road is free, the madness will go. So it's flexible. Now, but then the point I'm making, a joke apart, the point I'm making is that those lucid intervals where the person is not insane, you know, I mean, the person can go into a valid contract. The same thing applies to drunkenness. Someone is drunk. When you are drunk, you go into so you have to pay attention also here as businessmen and women. You go for a meeting and you are not even started the contract. They're already giving you drinks. Take this one, go and take tea. So you already got drunk before the contract negotiation started. And they ask you to sign here. This person has been hospitable. He's very caring. So I don't want to argue with him. Just sign here, you sign. When in fact you are drunk with alcohol. So the issue is that once you are drunk, the law is the same test of madness that the law apply. That you are not in the state to do. So a drunken person also don't have the capacity to enter into a contract. So you will go for a meeting and someone is offering you to drink first before meeting will start. You have to be careful too. Because they're taking you there. But of course you have an excuse to show that, I was drunk. See that capacity is also a valid element of contract. Okay, so ladies and gentlemen, so today we're able to cover these elements. I expect you to go and read further on all of them. Any question? Dennis. Dennis,
Good
your
evening.
hand is
Good
up.
evening, sir.
Yeah.
Okay. So I want to ask based on what you said regarding that the case of the pharmacy who sent someone abroad for training.
Yeah.
Sorry, I didn't get exactly on what ground you said the case did not stand. Is it that because their object of clause or object clause does not include training someone, or that because they are not meant
The
to have a doctor in house?
in house. They want me to have a doctor in house.
Okay, but if it is about that they if okay, let's say for example, if they did that to a pharmacist, they could have won the case, correct?
If they train, if who would, that person trained was a pharmacist, they would have won the case, of course.
Okay, okay. That's what I wanted to just confirm. Thank you.
Exactly. Of course, they would have won the case if they trained a pharmacist, because that's what this
Okay.
person was doing. Yeah. So that's why you have to watch. That's how you have to watch your object clause very well. Because when you are sending your staff for training, make sure that the training you are giving your staff is in line with the object of the company. Otherwise, you're wasting your time.
Okay, but as a follow-up question, what if I have a business, right? And because I am planning to expand, let's say I'm in a business now, and we're planning on, backward integration for a certain process. And because we're thinking about that, we know we're going to do that at some point, then we now decide to send someone in training, all right, with a bond, hoping that by the time he finishes that training, maybe in a year or two, the other business line would have been ready. And then he comes back and say that he's not willing to work for us on that particular thing. Maybe at this point, we currently do when we enter that into that bond, we currently do not have that line of business.
Hello.
So,
Can't hear you again, Dennis.
hello, sir.
You're saying about
Hello?
bounds. When you say something bounds, and then you.
Okay, so what I said was that let's assume that I want to do a backward integration for a business. Maybe there's a process we run that we want to have a backward integration for, right? And then because we already have that plan, we know we're going to need capacity in that regard, like human capacity. Then we decide to send someone for a training, for like 2-year training, to prepare, maybe to prepare that person for that position when we eventually start that operation. And then maybe we enter into a bond for that. At this point, or at this moment,
just have it in mind that the goalpost is the object clause. So that's why you have the right to amend. You can always alter your object clause if you want to go into new businesses or new engagement or new contract, and they are not covered by this. First of all, what you do first is to go and amend the object clause, add that to it, and then you go on and do it. That is the safer way to do it.
Okay.
It can't cost just a day. It's just a day. Like less than 30 minutes, you would have already amended your. Just go online and then you submit. The CSC will send you a new memorandum, certificate covering all those new things. That's all.
Okay, so
but it's better secure your house
I'm asking, can we amend the object clause? Let's say
as many times as you want. As many times as you want.
We are planning to do something in 2 years. Can we just amend it from now?
If your course, if what you are doing in 2 years is not covered by your object clause, you can't. Otherwise, what you will do ultra virus beyond your powers. So what you do is, first of all, make sure that it's covered. They will have the powers to do what you intend to do in 2 years' time. Make sure that it's in the object clause of the company.
Okay.
Yeah.
Okay. Thank you, sir. Yeah.
Welcome. If we don't know how to do it, bring it to us. That's what we'll do. We'll do it for you. Then the colleague, you are asking the question indirectly. You want the legal advice indirectly. Blessing, fire me. Yes, time has fast spent, but you are asking questions. Me, I'm sitting in the office, so you are taking dinner. You are even relaxing your houses. Me, I'm sitting in the office. It's like no balance. So, Blessing.
Okay, good evening, sir. I'm sorry,
So
I
where are
just
you?
got a message that you've been trying to call my name. I'm not sure if it's my blessing. I just wanted to clarify that I'm in class. I only just stepped out now.
No, I'm not sure I call Blessing in my class. Maybe someone needs to know.
Okay, thank you, sir.
Okay, thank you. All right, so in the absence of any other question, someone should move motion for adjournment so this court will stand.
I moved for the adjournment of this class.
Who is that lawyer? Who is the barrister? Who?
This is Barrister Chiwiti.
Okay, you are moving a motion, Navi.
Yes, I
So
do.
for adjournment. So when is the court going to adjourn? Which date is the court going to sit again?
Well,
At the
next week
infinitum.
or infinite.
Next week.
Okay, next week.
Next week. When you seek adjournment, you look for a date now. Which date? You have to give us a date that we adjourn. We are joined to which day?
Okay, the 10th of July.
Okay, that should be next week.
Yeah, most likely next week.
Next week. No, it's not your most
Eh,
likely. We'll dial there with you.
Next week, Thursday.
Yes. So okay, lawyers in the house. Do you agree with that date? Next week Thursday we meet here again by 6 o'clock. The lawyers in
Agreed.
the house.
Yes, sir.
10th July 2025.
Okay, that's convenient for all the lawyers in the house. Okay.
Yes,
All
sir.
right. Second.
Convenient for the lawyers and the barristers.
Yes, in the house. That's fine. That's fine. So see you on Thursday next week by His grace. Bye.
Bye.
Bye.